Well, thank you very much. It's great to be back, um, and great to follow up on a very interesting first panel with my colleague Dr. Zhang and Filippo and Heng. In this panel, we're going to be looking at China's inward and outward foreign investments under the rubric of opportunities, challenges, and responses. Just to set the stage, for nearly 2 decades, one could have almost said that there were 3 truths in life: death, taxes, and expansion of the Chinese economy. Well, over the past, since COVID, we've seen slumps in that once formidable truth, and part of the slump has been in inward and outward investment from China. There's a growing question as to whether or not that is simply a blip and will readjust itself and back to normal after COVID, or whether this is the suggestive of a longer-term trend or longer-term realignment, and what might be causing that. One thing we can note is that during this period, there's been a lot of activity in Chinese legislation and rulemaking with respect to foreign investment, whether it be the Foreign Investment Law of 2020, whether it be the National Security Screening Laws of 2021. There has been a considerable amount of regulation, which has, on the one hand, served to being targeted towards liberalizing investment into China, and at the same time also monitoring or restricting investment into China as the Chinese authorities see appropriate. At the same time, we also have China's outward investment regime, its ongoing Belt and Road project, amongst others, and the more general outgoing investment by Chinese companies around the world. In this panel, we'll be looking at both. We'll be looking at inward investment into China as well as outward investment from China. And we're very fortunate to do so with 4 distinguished academics and practitioners in the area. So let me introduce them briefly so as not to take away from our time. In alphabetical order, Professor Vivian Bath is a professor of Chinese and International Business Law at the University of Sydney. She's also Associate Director of International at the Center for Asia and Pacific Law. She's the author of the multi-edition volume Law and Business in Australasia, and author of an article I have found particularly interesting: China's Role in Developing International Investment Law. Our second panelist is David Boiteux of Gilles Loette and Noël. He's a partner in charge in the Shanghai office of this French law firm, where he has over 20 years of experience working with mostly European clients on their inward Chinese investments. Our third speaker is Professor Xingyang Kong, Professor, Dean of School of International Law at Chinese University of Political Science and Law. Professor Kong, among many, many other things, is the author of a forthcoming volume that sounds well worth looking at, called China's Foreign Investment Law and Evolving International Investment Rules. And that is coming out with Springer in 2023. And then finally, but not lastly, our fourth panelist is Patrick Yuan from Zhonglun Law Firm in Shenzhen. Patrick is a graduate of Sichuan University, Paris 10, and is currently among a very busy legal practice, impressively pursuing a PhD at Chinese University of Hong Kong. So I am most impressed by all those activities, I tell you. But Patrick is an equity partner who works on both disputes and M&A and cross-border investment into China as well as representing Chinese companies in their outward investments, particularly along the Belt and Road. So with that background, maybe we can pick up on something that we heard in the first panel from Yao Wen. And the words that jumped out at me were confusing, complex, when referring to the regime for China's inward foreign investment. And hearing those words, particularly in the context of an area in which China has made recent legislation, is kind of surprising. And I guess perhaps we could start off with Professor Bath. In terms of what China has been doing with respect to the foreign investment law and its other new regulations, what might account for this sense of confusion and complexity in the way that those laws have either been written or implemented?
That's an interesting question, because to my mind, the new regime is a lot simpler than the previous one, which had accrued over 30 years or so a most amazing complex of confusing and inconsistent regulations. But it is true, I think the Chinese authorities have become very fond of issuing regulations, and perhaps during the pandemic they had nothing better to do. So they issued more and more regulations. I think the issue is now that essentially you have a bit like a two-tiered approval system. So it's much easier to actually come into China, but then you have to jump the next barrier of actually getting your license and permits through the open market access scheme, which I suspect is turning out not to be quite as easy as it was. But I think the other part of it is actually probably not so much the investment regime itself, but the fact that the Chinese legal regime has become much more difficult, I think, to navigate your way through in many respects, particularly in relation to things like the cyber security law, the data information law, the national security law, and laws of this kind, which have associated with them an amazing amount of regulation. And I think a good deal of, shall we say, ministerial flexibility in the way in which they're applied.
I mean, I wonder, Patrick Kwan, in looking at the new regime that's being set up, from the perspective of inward investors, is this an advance in a rules-based system for for making investments into China, or is this still reliant upon ministerial flexibility and significant discretion at the decision-making level? I'm sorry, Patrick, that was meant to be a question for you. My apologies.
Okay. I'm sorry. I was supposing this question is for Professor Cole, maybe. From my personal opinion, I think the recent Chinese investment regime is a combination of two objectives. The first one is how to feedback from the U.S. challenges from the Chinese people's perspective, because there's certain sanctions specifically to the Chinese companies. So in 2021, we can see that Chinese government have the anti-foreign sanction laws. That is from the pressure of the United States. And on the other hand, we can still see, like Professor mentioned, we can see the internet security law, or the personal information protection laws of China, and data security laws of China. Those kinds of laws or let's say emerge suddenly, not only because of outside pressure, but also the Chinese government or the Chinese economy is facing the new crossroad or the new opportunities. We want to update to a new stage of the development. So those things like the protect the individual personal information on the internet and the data, all of those are how to say strictly related to the new economy, to the data economy, to the digital economy. So those kind of laws may have positive incentives to the domestic Chinese company to become stronger, to face international competition worldwide, like the Tencent, like Alibaba, all those kinds of companies, so that they can tape their technology advancement, and at the same time to meet the concern from the not only the United States but also the Europe, because Europe has the most strict personal data legislations like the GDPR. We're all aware of that. So those kind of laws, from my personal opinion, is a combination of the two needs. Professor?
Yeah, thank you. Professor Kang, I wonder if I can follow up on something that Patrick Wan has said, which is the role of the United States in the role of the United States as a driver for changes in China's foreign investment regime. How big a role does U.S. policy and seeking to address U.S. policy has it played in these developments? I just want to remind you, I think you're muted. Prof. Kang, you are muted, I'm afraid. There you go.
I have some technical problem. Indeed, the law was adopted when U.S. waged a trade war against China. But I do believe this is not a result of the pressure from the U.S. Instead, it's a natural result of the high-level opening up of the Chinese economy. You can see the current foreign investment law is characterized with a high-level liberalization, which is represented by the so-called pre-established national treatment plus negative list. Under this system, the government has less policy room to intervene. It's not in a position to decide whether to accept or refuse prospective foreign investment, given the negative list. It has no policy goal to achieve so-called development goal. It does not have the policy tools to realize its development goal. The government has less power to intervene, and particularly when it comes to technology investment. Forced technology transfer is strongly prohibited by the law, and this has been enshrined in the foreign investment law. So I do not think this law is just take a small step towards a private or I should say, it does not represent a small step on the top of the existing regime. It does represent a giant step because of its high-level liberalization, because of its the less room of the policy for government to intervene the upcoming investment. This is I would like to say. Yeah.
Thanks, Prof. Kong. Mr. Boiteux, you are working with clients on the day-to-day, and we've heard some different characterizations of the new investment regime in China. After having been in China for 20 years, does this feel like this is a paradigm shift, or in terms of approach of Chinese regulation?
It is, but it has been in reality very progressive. I mean, indeed, the foreign investment regime and control is not that an issue for most of our clients. I would put aside the sector that are still under severe restriction, what we call small yard with high fences that are not accessible to foreign investment. If we put aside that, but it's very limited to sensitive sector, most of the industrial services sector are now almost fully open. But it's easy, I would say, for China to open this sector now, because for many years, it was under severe and huge restrictions. So all the local players have developed very much during all this period. So at the time when they opened the sector, the market access is much more difficult for foreign players than it was in the past. So the main issue for our client today is the one with what mentioned by Viviane, is the huge amount of regulation, the complexity of the regulation that creates a lot of uncertainty, a lot of work for us, of course, but a lot of uncertainty for our clients. And the fact that the competition from local players is, for some sector, difficult to face for most of our clients. So again, for most of our clients, it is not the foreign investment legal regime that is an issue, it's the access to the market, to the open market.
And let me stick with you for a follow-up question, and this is coming off of something that Viviane Bath had said during our pre-chat. How much, in addition to the law, is relevant to your understanding and as a practitioner, your advice to your clients? Does the law tell us the entire story about the regulatory regime at the moment for market access in China, or is there additional, whether they be political, whether they be relational types of considerations that come into play?
Yeah, the law does not say everything, of course. You have basically practical barrier to the access to the market. To give you a very concrete example, if I look at the public procurement, which is one of the big sector for our client as well in China, because the state-owned enterprises, the state is spending a lot of money on the market. So it's public procurement is a big issue. The law is pretty clear on the fact, and maybe Patrick, you will confirm or not, but the law is pretty clear on the fact that there should not be any discrimination between local player invested by foreign investor and a local player purely domestic. In reality, this is one of the main concerns of our client. They don't have access to the public procurement as a supplier. So this is this kind of barrier that we have, which are very practical, very political, that are not in the law that we are facing now. For the license part that was mentioned by Viviane, it is more a troublesome issue. But to be honest, we managed to get the license, even though it's time consuming, we managed to get the license and we don't have that much issue in that respect. But practically the access to the market and to develop business is becoming a big issue. I just want to mention one more point, which is also a practical aspect of it, is that the way to do business, I would say, to put it in a political correct words, the way to do business from local player is not exactly the same as the way a foreign player would do business in China. So it's also creates some unfairness, I would say, in terms of development in China.
Patrick, I wonder if you experience similar
Yeah.
similar things in your practice?
Yeah. In my practice, I do have some similar feelings. Law cannot be the only factor to consider when the foreign investor invest either in China or in the other Asian countries, or either in which specific cities. For example, in the last 20 years, where I'm working is Shenzhen. Shenzhen is an economic dynamic city. It's developed so fast compared with other cities. However, other cities have all similar laws like Shenzhen. Like before, when China opened up, said okay, 5 cities would be opened up. Only Shenzhen finally survived. Finally comes to be become from change dramatically from a little village to a big city now. So what is the reason that Shenzhen attract a lot of investment, and so many companies can, like Huawei, like Tencent, can be born here and grow up? I think law is one part of story. The other part of story is that the local government, those people who are really like open their mind up and work for the companies. All the policies, when they enforce the laws, and the court, of course, the judges and the arbitration institutions, they are strictly follow the law. So businessmen know, okay, here's the rule, and if I follow this rule, I can gain money. For example, one of my clients is from the United States. They invest several factories in different cities in China. Now, since the whole economic is not that good, so they close some factories, but they still keep their Shenzhen factories, and the Shenzhen factories become grooming. Last month I met with their CEO, and they said that okay, even how the real property in Shenzhen is high, the price is high, living expense is higher. However, here they do not need to afraid the sudden investigations from the local government, or some unseen tax requirement from the local government. Several things like this. Because the law, when the law changed a lot during past 20 years, if the government want to do something evil, they can still have some excuse, like lawyers. They can grab for different excuses or different agreements. So how to attract more investors globally? I think it's more we're going to see how the local governments, the local courts, judges work, and the lawyers. I have also similar feelings when I attend hearings in different cities. When I present my clients in Shenzhen's court or Hong Kong's court, now I cannot go to Hong Kong court due to the bar. However, I can go to Hong Kong do arbitration. So I go to a tribunal hearing. I only need, what I'm going to only worried about is my case, is my document. The law, what is law saying? However, if go to the other court, things going to be slightly changed. So that's what part of my experience. I hope that answered part of your questions.
Thank you very much. I mean, Professor Kong, I wonder if I can come back to you with and pick up on something that you were mentioning. And as I understood your remarks, you were talking about China having less of a right to establish policy priorities for development as a consequence of the increased liberalization in the foreign investment law. And I guess my question is where, when we look at the foreign investment law, we see the incentives that are available for investors making investments on the encouraged list. What kind of development is China seeking at the moment? Is it economic growth? Is it sustainable development, climate change sensitive development?
Apparently, development goal is embedded in the heart of the government when they are to attract foreign investment. And the law, on one hand, narrow down the policy room for government to intervene, but on the other hand, the law provides incentive which are legitimate, which shall be legitimized. Yeah. So they are under certain, certain power limitations. So they need to act in accordance with the power authorization. So, but still the incentives are there. The incentives are generally provided to high-tech foreign investment. The incentives are provided to those that will deliver, let's say, green development, so on and so forth. But as I noticed, some people, because I'm personally involved in local legislative project on foreign investment. I do hear the complaint from foreign investor that the government possibly sometimes do not strictly abide by the law, like public procurement, so on and so forth. But still, we see a very interesting phenomenon. These years had witnessed the rise of foreign investment. For example, in 2021, saw a two-digit rise of foreign investment, incoming investment. And in 2022, a further steady growth was seen, which represented an increase 60.3 year on year. Let me repeat. The year 2022 witnessed an actual use of foreign investment exceeding RMB 1.2 trillion for the first time, which represented an increase of 6.3% year on year. So can you imagine? So on one hand, people are complaining about whether the law has been strictly implemented, but on the other hand, the foreign investment is still increasing. So this possibly poses a very interesting and sometimes conflicting picture of what and how the Chinese foreign investment regime is about, whether it's for investment friendly or it's not that friendly as stated in the paper of the law. So that actually is a real question from my point of view. On the other hand, I also see the current competition, strategic competition between the US and China actually are having offsetting impact on the positive role of the foreign investment law, at least from the letter. Because some foreign investment, particularly from the US, are exiting the country, and some potential investment are slowing down their pace to investment. But nevertheless, we see a very interesting picture, as I just mentioned. The total investment is still increased, and sometimes possibly it's beyond explanation just based on the current law, or particularly based on the complaints from the foreign investors. So this actually is something that I would like to convey. Yeah. Thank you.
Thanks very much. Obviously, it is a complicated picture, especially when you're dealing with a market of more than 1 billion people. That has its own pull on commercial decision making, well beyond the letter of the law. But Professor Bath, this was your observation in our sidebar before. So let me give you an opportunity to expand on your thinking about the law in practice and the law as written from the perspective of investors operating in China.
Yeah, it's an interesting question, I think, to what extent law actually does attract investment. Perhaps it doesn't attract it, perhaps it just doesn't stand in the way of it. It's the economy which actually attracts the investment. I think the real problem, though, has always been with China, is that you have business and you have the law and you have politics. And what we always try to do, or what business tries to do, is pretend that there are no politics, that there is law, that law is rational, that law will be consistently enforced, that it will be applied as it's written, and therefore business can operate on that basis. In fact, of course, that's not always true in China. I mean, as Patrick was saying in relation to the courts, Shenzhen's success is due to its ability to actually provide some degree of consistency. But as we all know, we have examples consistently also where politics actually intervene in terms of the way in which the law operates. So the current very prominent ones, of course, are the raids on the consulting companies, Mint, Bain, Capvision, companies which do due diligence. In the past, we had the BHP employees who were put in jail for stealing business secrets and for taking bribes, enormous fines imposed on Glaxo. And of course, coming from Australia, we're perhaps a little bit sensitive about this issue at the moment, because we had several years of quite arbitrary trade sanctions imposed upon Australian goods because of political disputes, essentially between the Australian government and the Chinese government. And although you can say this is trade, not investment, it is of course all related, because it's all politics and it's all formed by politics. So a consistent difficulty, I think, is that despite the many improvements that are made to the legal system, and going along with those, we could say all the improvements which are made to the justice system and the arbitration system, which the courts and the Supreme People's Court work on all the time. Despite these many improvements, you still have this side-by-side issue as to what's happening in the political sphere and the impact which this can actually have on the way in which the law operates and business operates.
Thank you very much. That's an interesting segue, then, bringing up politics, and particularly two aspects of legal development in China that I wanted to close out our discussion of inward flows of investment on, and particularly that's the anti-foreign sanctions law from 2021 and the measures on security review of foreign investment, also from 2021. I'm not an expert by any stretch on China, but it's hard for me not to read those laws as relational to U.S. practice and long-term U.S. practice in terms of pushing back against U.S. secondary sanctions on third state countries for dealing with entities that the United States has directly sanctioned. So the anti-foreign sanctions law, and also in terms of the rather wide scope that the U.S. Has exercised with respect to inward foreign investment through the Committee on Foreign Investment in the United States, the CFIUS process, seeing that in the measures on security review. And I think it's noteworthy that in a way it's not just China that has instituted laws like this, but we've seen analogs to these kinds of pushback laws in the European Union as well. So after a number of decades of U.S. Hegemony in this particular area, if you like, you see larger economies pushing back. I guess, Professor Kong, in terms of the new anti-foreign sanctions law, what's been the use of that law so far in terms of yes, go ahead. Let me just leave it there.
The anti-foreign sanction laws have been implemented for a couple of years. So far, the law has been used to target those foreign nationals or foreign institutions that are regarded as having infringed the sovereignty, the national security, as well as the development interest. Of course, this is broadly interpreted. You need to interpret it specifically. For example, Nancy Pelosi, the speaker, the US former speaker of the House of Representatives, was sanctioned after her trip to Taiwan. And other US congressmen were also on such a list of sanctions under this law. But you can find all the sanctions that are imposed by the Chinese authorities against foreign nationals or foreign institutions are primarily a response to what has been done by the foreign national or the foreign institution that have been regarded as having infringed the sovereignty or the security or the so-called development rights. But I do believe when it comes to the implication of this law or the sanctions on the investment, I do believe both the US unilateral sanctions and the China's legislative pushback have nothing but an intimidating impact on the existing Chinese investment in the US and the potential Chinese investment inflow to the US. The Chinese companies in the US and the potential Chinese investors that are interested in the US market have to take sides. They either have to abide by the US law or the Chinese law. So this uncertainty actually has posed a systemic risk to the US legal environment for Chinese investment on one hand. On the other hand, this has a substantial impact on the Chinese investment in the US. You can see quite a number of Chinese companies have delisted for the US stock market, for the New York stock market. Quite a number of big companies like China Telecom, China Unicom, so on and so forth, has exited, has left the New York stock market. This apparently either is out of the potential threat or out of the or in fear of the potential sanctions. So they just left. They just left. So you can imagine they actually, as long as this kind of measure continues, and the environment will certainly not be friendly to Chinese investment. But of course, the Chinese investment actually have no way but to leave. So this actually is a tragic phenomenon, not instrumental to both sides. This is what I would like to say. Yeah, thank you.
Thank you very much. And I want to move to look at Chinese outward investment in particular. But before we do that, David, from the perspective of a multinational making investments in China, although the law is new, what kinds of impacts are you advising your clients to be aware of with respect to this development?
Yeah, this is actually quite an issue for many companies. I mean, whether sanctions from US if you deal with certain company in China, so if you're a European company, you have business with a Chinese company which become under sanction under US, then it's a big issue for the European company which has business in US, right? Whether it's sanctioned from China of certain business or certain partner, this is also as an issue. So the main consequence of this potential sanction, all countries have the tool now to implement sanction, is what we call now in China de-risking. So this has today a practical consequence. It means that companies will look at whether they should stop international trading. So whether they should, instead of having supply from abroad, instead of having certain functions supported from abroad, to have everything localized, because they don't want in a situation where from a day to another, because of a sanction from either party, they will have to stop business that is interconnecting between countries. So this is a very practical consequence of all this tension, this geopolitical tension, and the law that are promulgated by all these countries, that how we can do business safely on a long-term basis in China. Maybe we should just do local, everything local, supplier management, data protection, cybersecurity, everything will be in China. So it's called decoupling, de-risking. It depends a bit of the term, but this is the actual today consequence of that. This is my client. They are looking at how to deal with that now, right now in China. And this is huge because when you're a multinational, a big company, you may have the means to do that. When you're a medium-sized company, you don't have the means to localize everything in China. Financially, this is not something that is feasible. So there will be indirect consequence in terms of foreign investment linked to this sanction-related regulation.
Mm-hmm. And Patrick, is that what you're seeing in your practice as well?
Yes, I have strong feelings. The new economic trend and the new world political situation change, the atmosphere change that did influence the foreign the Chinese investors investment outbound. For example, last week, one of my clients finished his trip in Europe. He come back and he said to me, okay, I think now it's a good time to change or to switch part of their factories, their research line into the Europe, because the Sweden government promised a big package, like the promotion of the electricity, free place to use as a laboratory, and a lot of packages, and including the visa. So the CEO of that Chinese company is thinking about, okay, now we have considerable European clients. Now maybe it's good time to invest in Europe instead of to put all the packaging in China. So I can say, and from the Sweden part, I heard about my colleagues in Sweden, the Sweden lawyer. They said that, okay, because there is a war between Russia and Ukraine, so they also for the European companies, they also worried about their security, their supply chain. So they encouraged more suppliers, the factories, increase their investment or their factory scale near their own country. So that's one good example how that did influence the Chinese investors think about. Before they were think about like Vietnam or Bangkok, something like that. Now they even think about, okay, why not directly go to the United States, go to the Europe? So this is a new trend for this year.
Mm-hmm.
Thanks.
And maybe that's our segue then to outward bound investment and looking at outward bound investment. And I've mentioned the U.S. the U.S. regime for screening inward bound investment already a couple of times, and the Trump regime was characterized by an increased scrutiny on Chinese investors making investments in the United States, and the use of the CFIUS regime in a way that hadn't really been seen before in terms of its impact and its prevalence. And in advising outward bound investors, how does that feature in whether or not to recommend investments in the U.S., or does it how disadvantageous is it seen in terms of making investments in the United States? Perhaps, Patrick, I can turn it back to you.
Okay. That is really a good question, but also a very complex question. Now, one of my clients, they're like Fuyao. Maybe Fuyao, that company. They make the glasses, the high quality glasses to avoid the noises and to put those glasses into vehicles or the aircraft. They were attracted by the Trump policy. They set up the new factory in United States because of all those tax and reimburse incentives to set up the new factories to invest in the United States. However, now they also meet big problems or cultural conflicts, like they compared to in China, they feel it's hard to find qualified and skilled workers. That's the first thing. Second thing is that people in the United States do not like overwork. So it's the compliance, or I don't know how to describe that, because the compliance or somehow the culture is totally different. People, when they think about the scope of work, is different. The Chinese worker and the United. So I say that there's a problem there. That's the second thing. The third thing maybe is that when they're doing business, they also see the long-term goals. Chinese investors now really worried about the tension between China and the States. So that tension also makes them some kind of hesitate to make further investment in the United States. That's one part of the picture. The second part is like Professor Johnson, what you mentioned about, because the security concern for those good to the Chinese investors, the good assets or the good target, the Chinese investors cannot invest due to the U.S. Foreign investment regime. Like they go very hard or sensitive review, CFIUS review, all those procedures. So that part do refuse or scared a lot of potential Chinese investors.
Vivian, Australia also has a relatively recent revision to its security screening law. Is that essentially a revision or targeting potential investment from Chinese investors in Australia, or certainly not only, but is that a driver for Australian policy with respect to inward investment from China?
Look, Australia rules on inward investment like Canada's are actually have always been much tougher than the US, really. They make CFI US look pretty mild when it comes to it. And our first amendment to our laws really to deal with Chinese investment goes back to 2008, when there started to be a lot of Chinese investment, particularly in minerals and energy. So it's something that we've always been conscious of. And being a smaller economy, actually, that's not limited to China. You know, it's US companies fall foul of this as well. And I think that actually one thing Patrick said sort of raises the problem, which is that a lot of this investment is acquisitions. So if what you have is Chinese, US, UK, Singapore companies coming in and snapping up Australian companies, Australian mines, Australian projects, then that's much less welcome than, say, a big company that comes in and wants to set up a new factory and a new business. Everyone would love a Chinese company to come in and set up a new factory and a business. That would be wonderful if they could find enough people to work hard enough to get it going, I guess, Patrick. But the latest revision to the Australian screening rules imposes a special national security test. And this is actually mainly because of the emphasis on critical infrastructure and critical minerals. Okay, because China, the thing about Chinese investment overseas is you've got private sector investment, which is essentially commercial in nature. And then you've got state-owned enterprise investment, which is partly commercial, but is also quite often directed by government policy. And one of the things that Chinese companies, of course, or Chinese state-owned enterprises have always been after, they've always invested very heavily in minerals, they've invested in energy, and so the things they go after are things like lithium, rare earths, all of these things which countries like Australia, Canada, US have rather belatedly realised we should actually be producing ourselves. Because Chinese companies worldwide have managed to snap up an extraordinary percentage of things like rare earths and in particular sectors because they've been focused on it, because essentially they have been paying attention to all of these things, whereas the rest of us haven't. And so the national security amendments are really directed at that, whereas quite often previously it's done on a one-by-one basis. But we've discovered that doesn't necessarily serve very well to look at things just on an individual project basis. You have to look at things sometimes on a broader basis than that.
Prof. Kong, I mean,
Yeah.
looking at the prospects of Chinese overseas investment, particularly in developed economies that have, let's say, complex regulatory regimes for addressing inward bound investment. I mean, is this concern that's found in Western countries like Australia, like United States, for the independence of Chinese state-owned enterprises? Is that a well-founded concern, or are Westerners misunderstanding the nature of Chinese SOEs?
Yes, I do believe there is a risk that national security is being misused or at least overused to regulate foreign investment. And unfortunately, the case not only can be found in the developed country, but also can be found in China as well. But of course, I would like to say, actually, China has been targeted. Chinese investment have been singled out for scrutiny on the basis of national security concept in many countries. And this actually has posed a serious barrier to foreign investment, Chinese investment in these countries. And of course, China is particularly concerned that the Chinese state-owned enterprises are singled out for their links with the government, even though China has been arguing that the state-owned enterprises of China actually are commercially operated by their own, even though this possibly is not that much convincing. But nevertheless, state-owned enterprises, they themselves cannot be a reason for them to be singled out for scrutiny only when there is evidence that the state-owned enterprises has a close link with the government, particularly they received directives from the government or something like this, then I think they should be reviewed, you know. Otherwise, by nature, that's a discrimination. This is what I would like to say. Thank you.
Thanks very much. And I'm conscious of the fact that we're drawing to the end of our hour quickly, as I supposed, given the interesting topics that we have to cover. But perhaps we can just end up on that point that Professor Kong raised about Chinese SOEs. It leads me to think of the use of investment treaty protection by Chinese overseas investors, and the Beijing Urban Construction Group case versus Yemen, in which the tribunal there confirmed the status of the SOE as an investor as such for the purposes of the investment in the ICSID Convention. One thing I noticed is that we see Chinese investors using Chinese investment protection treaties at an apparently increasing rate. I think I saw 17 claims now having been brought. Vivian Beth, do you see this as something that we might expect more of going forward? Because we of course haven't seen that many claims where China is the respondent.
We are beginning to see more where China's the respondent. There are 8 at the moment, or 8 have been brought all up. As you say, I think there are 17 that have been brought, though Huawei is threatening to bring one against England, or has issued a notice against the UK. So yes, but you know, Chinese companies have been encouraged for some time by the Ministry of Commerce to take advantage of the treaties. With mixed success, they've had some wins, they've had more losses. And part of this is, as Yawen was saying, because the older treaties, the ones up to about 2000, which is 2/3 of them, have very, very restrictive terms. They were there originally, I think, to benefit China so that they really couldn't be the victim of investor-state arbitration. But now they're beginning really to count against Chinese investors. So the latest one, for example, against Ghana was knocked out on the basis that essentially the treaty was too narrow to allow investor-state arbitration. But I think that there will be more of those, and probably more against developed countries also, not just developing countries.
And Prof. Kong, do you see the revision of China's older treaties to bring them up to date and perhaps provide more protection for Chinese investors as a priority for MOFCOM?
Actually, you possibly have known that the current bilateral investment agreements actually contain a provision which entitled the Chinese investor to resort to arbitration only when a compensation issue is only concerning compensation issue. So whether the foreign government is in a position to expropriate, to take the Chinese investment, actually is not an issue for the Chinese investor to argue at the International Arbitration Tribunal. So the current investment agreements actually cannot provide the right remedy for Chinese investor in foreign countries. That's why the country, I think, has been and is still being updating the foreign investment agreements, including the free trade agreements with the investment chapter, so that more possibility will be there for Chinese investor to bring the foreign government into the International Arbitration Tribunal. It has been doing so far, but the progress has not been so dramatic. Thank you.
A lot of treaties to update. That is absolutely true. David, perhaps I will close with final question just for you because we're at time. But in working with your foreign clients in China and advising them, well, this is not an easy question maybe to answer, but to what degree does the possibility of bringing an investment treaty claim against China factor into the discussions that you might have when grievances or difficulties arise?
This is a discussion that I have actually with some clients. I mean, they are concerned about whether they will invest a significant amount of money in the coming years in China, and they are asking me whether they have enough protection in that respect. As you may know, that there is an ongoing negotiation on a new treaty between Europe and China. This has well advanced, has been a bit put on hold for pure political reason, basically concern of some European countries about human rights, not enough provision in the treaty in that respect. So it's all on hold, but this will move forward in the future, and this is something that definitely our client may use, as well as Chinese clients for their investment in Europe. I totally agree on that. They will use that if they have that. So this is a concern, and we are looking forward to have this new investment treaty between Europe and China, because this will make the things more complete in terms of dispute resolution with the goal to use them. So this is something that is indeed something that we are dealing with right now. I just want to add one point, which is also something maybe for another debate, but it's quite interesting in Europe, is that beyond the foreign investment control, I mean, one of the main concerns of Europe now is to ensure that Chinese companies are doing business in Europe in a fair way. European countries are very welcoming to Chinese investment. Viviane, you said that the US is mild. I don't know what you would say about Europe. They are loose. They are very welcoming Chinese investment, but they are concerned about the fact that these Chinese companies, including state-owned enterprise, not for security reasons, but for subsidies that they obtain in China that make the competition unfair in Europe. And last year in Europe, we have a new rule at the European level where the European Commission has the right to challenge some business of some Chinese company if they consider that they have been subsidized by the government, which is a new regulation, which is very important. So the main concern of Europe now is not screening too much the investment. This is a concern in strategic sector, but not in most of the sector. The concern is to be sure that Chinese companies are doing business in Europe in a fair way. This is a key issue for Europe.
Thank you very much, David. That will have to be the last word, and it is an excellent topic for another discussion. Let me just thank Viviane Bath, David Boitou, Tianjiang Kong, and Patrick Huan for your contributions this morning, this evening, this afternoon. Let me also thank, just from our first panel, Filippo Fontanelli, Heng Wang, and my very dear colleague, Yaowen Zheng. Please do look for Dr. Zheng's book. It is a very good and interesting book for those interested in this area. And with that, I thank you all in the audience for attending today. I wish you a good day and hope to see you at another webinar from the Center for International Law soon. Take care. Bye-bye.
Thank you.
Thank you.
Thank you.